dismissal, there is what we call summary dismissal, where you not need any notice from your employer, because one, you've just breached the rules of a company. So with summary dismissal, in case you've breached any of the terms of your employment, let's say like currently there's been just an amendment of the Employment Act. If you've been away for 30 days without the knowledge of your employer, the employer does not have any obligation to give you a notice that they're actually going to dismiss you. If you look at the Employment Act, much of it is more or less to protect the employee. It's there for the employee. Even when you look at the labor officers, even if you look at the industrial court, it's more or less centered on the employee. So there are laws that are there to help the employee. The only challenge that people have is that people actually are ignorant.
Welcome back to the Benny Talk. This is a space where conversations are happening, real voices are heard, and also real stories are shared. Yes, for those who have been following us or watching us, you know, Benit used to be our host, but today things are a little different. I'll be taking over the mic. Yes, ladies and gentlemen, my name is Farhiya Abdiqani, also known as Miss Gwal. I've been here as a guest, also the lady behind the blogs that you see on our website. Yeah, check out those pieces and you'll find amazing items, CV templates. Please check out our website. Yeah, for today's episode we have an amazing guest, actually a returning guest. Yes, he has been here before and I think we had a great conversation the previous episode, so we had to bring him back. Ladies and gentlemen, Simon.
Thank you so much for here. I'm delighted to be back again on the Benny Talk and be hosted, and I'm delighted and looking forward to how it's going to be like as we inform the public and maybe on matters of the law and
We've had an amazing conversation last time. I think you had it with Benit, and we were talking about land scams, and I was watching that video. I took notes. I think I have knowledge right now.
Oh, that's amazing.
Like, that's to be honest, yeah.
That's very
and
good.
You know what they say, when conversations are good, we need to return the guest, right? That's what we have done.
I'm just here for you people and the people out there.
Yeah.
Well, my name is Semuwemba Simon. I'm an advocate of the High Court of Uganda and all subordinate courts. I'm a practicing advocate in Uganda and also a member of the East African Law Society, Uganda Law Society. I'm practicing at a law firm in Kampala, Uganda. And I'm delighted to be here and to share information and knowledge.
Yeah, ladies and gentlemen, that is Simon. We are going to be talking about one of the most important issues that we all face at work. You've faced issues at work. This is rights of, the rights that you have at work, people being dismissed unfairly. That is what we are going to talk about today. I think, Simon, you can first tell us what dismissal is all about, like the whole concept of it.
Well, it's usually when you are probably going out in the street, in the towns or everywhere, you'll find people who say, I've been unfairly dismissed, I've been wrongfully terminated, I've been unfairly dismissed. And sometimes they actually do not know what is next. Now, dismissal, usually under the law, of a Ugandan law that governs employment, is usually the Employment Act. Much as there are other laws that could be occupational safety and hazard and many others. I wouldn't want to be so much legalese. But there are very many laws that actually deal with the employee, because it's a relationship between the employee and the employer. So many times with dismissal, because when you enter into any workplace, the first thing that probably you have is probably a written contract of service. And therein, also probably in addition to that, is probably an HR manual that probably shows the rules, the do's and don'ts of that organization. So in case you breach any of those do's and don'ts of the organization, then you can be charged or can be got under the case of dismiss. You can be dismissed because you've not been able to follow the rules and regulations of those organizations. But also the rules and regulations of organization should and must be in compliance with the Employment Act, because the Employment Act has put many things like, let's say, sick leave, paternity leave, maternity leave, and any other things. So many times some people can come under the looking at the fact that actually I've not been able to breach any of the rules that you're saying that I've breached in relation to the Employment Act or in relation to the HR manual that they were given to as they were being admitted into the workplace. So dismissal, there is what they call summary dismissal, where you not need any notice from your employer. Because one, you've just breached the rules of a company, or even there's what we call lieu in payment, in payment of notice. In notice before you get any notice, they can because if you've been undergoing, let's say, unfair termination, your employer may not give you a notice, but they may give you like they can may decide to pay you in lieu of a notice. So with summary dismissal, in case you've breached any of the terms of your employment, let's say like currently there's been just an amendment of the Employment Act. If you've been away for 30 days without the knowledge of your employer, the employer does not have any obligation to give you a notice that they're actually going to dismiss you. So in case they dismiss you, then that is dismissal. But then you'll based on some other factors that could be that a person can say, no, I was actually wrongfully dismissed. I've been at the workplace, they are saying I'm not performing. But yet all year in, year out, the times that I've been, you've been actually been the employer of the year. And then here they are saying you've not been performing.
And yet they even promote you.
Yes, and they're even promoting you. That would be wrongful dismissal. You can actually say, actually, I've been wrongfully dismissed because I've been performing. Then the others could be, let's say, because now currently, according to the current amendment of the Employment Act, if a person has gone on sick leave, it must be after 6 months. So if maybe before the 6 months have happened, then all of a sudden the person is saying, we're dismissing you. That could be wrongful dismissal. Yes.
Also, you know what I've also realized is when you're new to a company or maybe an organization, what people mostly do is when they're given a contract, they just sign. They don't even read. I've seen that in several companies. Employees do not even read contract. So my question is, how do you know if the dismissal is legal or illegal?
How do you know if the dismissal is legal or not illegal? Well, the first thing I would say, reach out to a lawyer.
You know, some of us are scared of lawyers.
I know, many people are scared of lawyers, and they think that, oh, please give the lawyers their money. Anyway, so the first thing, how can you know that either your dismissal is either wrongful or not, or actually it's legal? The first thing is you can reach out to a lawyer to be able to actually look through your contract. But also personally, many times when people go to work and probably start up employment, the first thing is even they may not even be given contracts of service or probably an apprenticeship or contract. So the first thing is get your contract clear in order, put it in place and have it, make sure that you hold it like either your Quran or your Bible, let it be stick to you. But many people, most of the times actually, after they've done, they've got the job, they actually do not know even where the contracts are.
I know, right?
And you can't go to court and you're versing probably the other employer and you expect the employer to show this is your contract. So you must have it at like your Quran or your Bible. But away from that, there are small things that you have to see where wrongful dismissal could be. Let's say, a case in point, under the current amendment of the rules of the Employment Act, apparently for the first 1 and 2 months, in case you're having, let's say, sick leave, you must be paid for the first and second to the full payment. Then after the months that come, from 3 to 6 months, before you are terminated or you are terminated from work, you must be paid half pay. Now imagine you're having an employer who is with you and saying, but you've been sick for over 3 months. And then they say they terminate you before the 6 months happen. You can go and say, no, this is actually wrongful dismissal. You dismissed me when actually I wasn't. I need to have my 6 months. And also the law provides, the current amendment provides that before you terminate that person after 6 months, if they have a sick leave, let's say a person has got an accident, you must have a medical doctor report that actually shows that this person is unfit and that proves that they can unfit to come back to your workplace. But also, you realize that also wrongful dismissal can, like I told you earlier, a person maybe there's a workplace, a rumor This person is not working. Maybe they have a boss who's saying they're not working. But then when you look at their appraisals, actually they've been performing at over 80%, 90%. And then there are reasons that they're dismissing the person is because probably they're saying they're not performing. But if the person has the evidence of their appraisals and they're saying, actually, what you're dismissing me for is wrong, okay? Because I've been actually performing. Yeah. Or even they say you've not been coming to work, but actually there's evidence that you've been coming to work.
You've been signing, actually.
Yes, you've been signing or whatever, timesheets or something. And then the person is saying, you know, you've not been coming to work. You can actually go and say, please, by the time you dismissed me, it was wrongful dismissal. But also one thing you need to understand is that there's a difference between termination and wrongful dismissal. Because with termination, both the employer have the power to end the contract. You cannot force me to work for you, and I cannot force you to work for me. So you can decide and say, you know what? Yes, my contract is up to for 2 years, but actually I can compensate you. I'm going to end it in 1 year because I have a challenge that I'm facing with technology. Either my company is running out of finances or I'm running out of, like, I'm bringing up a new technology. Let's say now in this era of AI where people are cutting off people's jobs, you get it. What the employer in cases of termination has to do is to notify you before they actually dismiss you. In this case, if you have, let's say, employment for 6 to about 1 year, you need to get 2 weeks notice. In case you have probably you've worked for a company for 1 year or more, then you must meet like about 1 month's notice. And in case you have worked, let's say, for a company for more than 10 years, you must be given 3 months notice prior to any termination.
You know what is very funny? Most people do not understand that being fired without a notice is actually unfair, right?
Oh yes, it is.
It's very unfair. Yes, but we do not, some of us do not have the knowledge.
Yeah.
You know, let me give an example. If they fire me from where I work right now, I feel like I'll just be like, okay, you know what, let me just go. And then you find me in another company just because I do not have the knowledge. But I feel like if I had a lawyer, I would have 100% sued the company and the employer, right?
Oh yes, but you see, also you have to make a distinction. In case you're being fired under summary dismissal, in this case under Section 68 of the Employment Act, because now we talked about the summary dismissal, is whereby you are the one who is in breach. In case you've stayed away for over 30 days without knowledge of your employer, that one you do not need any notice. But for these others, whereby let's say the employer says that I feel I'm not going to renew your contract in the next, let's say in the next expiring at this point, and then I'm not going to renew your contract, and they're terminating you, they must give you like, if you've worked
2 weeks notice.
Yeah, no, 2 weeks notice is if you've worked for them between 6 months and 1 year. Now, if you've worked for them for over, let's say, 1 year and more years to come that have been, then they have to give you 1 month's notice. Now, if you've worked for over 10 years, for over 5 years, but not more than 10 years, then that's 3 months notice.
Yeah, I think that makes sense.
Yes.
Also, you know, when I say that some of us fear lawyers, what I meant by that is like, you know, suing a multi-million company is actually not easy.
Yes.
Let me give an example. Let's say you're working for this company and they kind of treated you unfairly, and you go to a lawyer, and then they're like, okay, this company is actually strong, like it's gonna be hard, and you find the lawyer is asking for an amount that is, you know, high. What should I do? Like, what could that person do? Is there any other alternative? For example, let's say the company has kind of treated you badly, not the employer, but let's say the company itself, you have evidence that maybe the employer has been treating you this and this, and then they are like, no, we are siding with the employer because he has been working with us for years. And then when you reach out to a lawyer, you find the lawyer is like, this company is a multi-million company, and I feel like we might lose the case, but yet you have all the evidence.
You know, many times people fear that this is a multi-million-dollar company. But the law that was, if you look at the Employment Act, much of it is more or less to protect the employee. It's there for the employee. Even when you look at the labor officers, even if you look at the industrial court, it's more or less centered on the employee. So there are laws that are there to help the employee. The only challenge that people have is that people actually are ignorant. And you know, there's nothing as bad in life when you're ignorant. So most people struggle because of ignorance.
Yeah, true.
That's why most people actually struggle.
I think, I think that makes sense. So who can actually claim unfair dismissal under the law?
To claim unfair dismissal under the law, one, the first thing that must be, you must be an employee. You know, there are very many things that actually distinguish an employee from, let's say, an independent contractor. Because let me give an example. You've seen many people who work in the banks. He might be a cleaner, but they're working in a bank. So to a layman, they would say, oh, I am an employee of, let's say, this current bank or this other bank. You get it? But now, when you are saying you're an employee of the bank, but unfortunately, the bank will say, you're not our employee. You are just an independent contractor. Because we do not have any contract with you. Because the company that hired you, you've seen people who work in factories. You realize that person is working for, let's say, this factory, but the people that recruited them, actually, it's not the company. Or if you look at their contract of service, it's not between the company and them. So there is a difference. You must be an employee to claim either unfair termination or a wrongful dismissal. Because you may be an independent contractor. I may not be directing you the tools of how you're going to do your work. You may not be an integral part of my company. So that can mean you may not be regarded as an employee. Also, you realize people will be on probation, maybe 6 months, and it's not ended up to 1 year. You cannot claim and say, I am actually an employee, because you're still under probation or even an intern. You cannot be under to claim that actually or receive the benefits of an employee. But also, the other thing is that right now in the current law, if an employer is going to you've been on probation, they must give you 1 month's notice that actually we're actually about to terminate you. Yes.
I think I've seen many people, many interns that claim to be employees for companies. But I think now we have knowledge about this, right? So my other question is, can someone be fired for refusing unsafe work?
Oh no. You should not be
when the environment is not, well, and then you're like, and then when you go and report, you're like, okay, I feel like I'm unsafe right now. And you report, but then you find yourself being fired because maybe you felt unsafe at work.
So as an employee, the first thing, there are laws that protect you as an employee. There's the Occupational Health and Safety Act. It is there to protect you. As an employee, you have the audacity to say, no, I'm not going to be doing this thing because it's actually unsafe. It's like telling me I'm going to work in this, but I'm not giving me the protective gear to handle this. And you see also employees, most of them, they're trade unions, labor unions, where they can be able to report such scenarios or even be able to go to labor officers and report and say, my employer wants me to do this kind of work, but they're not giving me safety gear or protective gear. So they cannot fire you because of actually, in regards to
being unsafe.
Yes, in fact, that can actually be one of the reasons you can have in the courts of law or before the labor officer to actually have and say actually as wrongfully dismissed. Yes.
I've seen people that actually go and report being unsafe at work, and most of the employers, what they usually do is fire them because of, if you're having back and forth with your employer and you're like, I'm having this and this, A and B, I'm having these issues every day, the employer will be kind of tired of you and they'll be like, okay, you know what, let's just give this person and fire him or her. And I've seen people literally leave without even complaining. They leave and they're like, you know what, since they fired me, let me go look for another job. But you have the rights to go and report them. You have the right to look for a lawyer, right?
Yes.
So let's talk about the employer side, okay? So what steps must an employer follow when terminating someone unfairly?
The first thing that the employer must do, the first thing, regardless of whatever, the first thing, if you have an employee, if you want to terminate them, give them notice. Like earlier we said, give them notice and tell them, I'm actually going to terminate you. In case you've heard them say these people actually have acted out of misconduct, the first thing is give them reasons, notify them that actually I'm terminating you on this issue. But most people actually, what they do, they just say, you're fired. There are people who are just like masters and professors in saying you're fired.
You're just fired,
They just wake up out of the blue and then they just say you're fired. So the first thing is give the person reasons so they can prepare their defense.
Yeah, true.
If it needs for them to go and get their lawyer, let them get their lawyer and come in the panel and actually defend themselves. And also don't just say that this is this. You actually did this, did this. Have the evidence.
Yeah, true.
Present that evidence to them so that they can be able to carry out their defense. But also, most employers, actually what they usually do, you find that the person, let's say, who is accusing is the HR. Or the person who is accusing is the CEO. But then when they come into the disciplinary committee, that very CEO wants to be on that disciplinary committee, or even the HR. And you see, under the law, you cannot be a judge in your own case.
True.
So you are the accuser, you are the prosecutor, and then you are the judge.
You are literally everything.
Literally you're everything. You get it?
Yeah.
So in the very end, somebody can say, no, the person could not give me justice.
Yeah.
They were biased. Also, the people who are choosing me did not present the evidence, because you have to tell them so and so is this is the person who actually, though you can handle, because there's what we usually have as the Whistleblowers Act.
True.
Something that can be used to actually protect, the people who gave you that information. You get it? So as much as possible, try as much as possible to give fairness to this person. In case maybe under your procedures, now let me give an example. You may find that some HR manuals say that in case a person has been dismissed, that person probably has a right to appeal in any other administrative body in your organization. But here you are, because you are mad at this person, even do not give them, they actually say, I want to appeal. But then you say, no, I will not allow you. You get it?
Yeah.
All that. So as an employer, make sure as much as possible that if this person is appearing before you, justice must not only be done, but must be seen to be done.
Yeah, true.
Yeah.
I think in short, as both the employees and the employers should have evidence, witness, because without evidence, I don't think you can even fight a case, right?
Oh, yes.
So, and also plus a lawyer, you need a lawyer, because why not? Yeah.
No, sometimes it's not a mandatory that before you go for that public, that hearing, you must have a lawyer. No, it must be. That's just like you can choose to say, let me go with my lawyer. Or you can say,
let me go alone.
Let me go alone.
Yeah, actually,
yes. But it depends, but it will be safer. Don't keep that money. Don't keep that money. Get that money to the lawyer. Get him and let him come.
Yeah, I think you're right.
Yes.
Yeah, I think you should get a lawyer. Get a lawyer, yeah?
But a good lawyer, not just any lawyer.
You're a good lawyer, right?
It's okay.
But yeah, and also let's talk about the rights. Let's say he or she was fired, okay? What are the rights of the employee now? What are his or her rights afterwards?
No, if in case you've been unfairly dismissed, there are very many rights that you have. First of all, you have a right to present the matter before a labor office, before the industrial court, or even to present the matter before court. But also there are rights, which, because if in case you have been unfairly terminated or dismissed, you are entitled to compensation.
Yeah,
let's say you have a contract of about 3 years. They have terminated you in just 2 months, in 2 years. And yet before the end of your contract, you're entitled to payments for as compensation for all the time that you've spent, that they have terminated your workplace. Because you cannot force yourself on an employer, and an employer cannot force himself on you. So in that case where you guys cannot work together, then the best option would be to compensate you in form of, let's say, severance allowance. Now, how is severance allowance compensated? Like for every 1 year that you have, there is that 1 month that will be for the time, for each 1 year you've worked for the employee. So that can be calculated as well. Also, you can be looking at also other damages. There could be emotional, according to how the lawyer can argue the matter in court. And also maybe the days that you've worked, maybe you must have been for your leave, but here you were working. So all that, you can the court can calculate all that and actually be able to compensate you.
Yeah, and what I always tell people is, you should always, I don't want to call it protest, but if it's the right word, let me use it. It's always good to protest, for the employers to give you maybe 2 months or 2 weeks notice, because finding a job in this economy is actually very hard. So you can just imagine you've dressed up, you're going to work, and then you find someone telling you, you know what? You're fired, and you don't even know where to get the job. Yeah. Also, I also want to
actually on that, I do not advise. Oh yes, I know people can protest.
Yeah.
But you see, when you have power, sometimes you don't have to show the power
way.
to. Okay, yes, you have the rights to protest or demonstrate. But you see, the challenge, most people, person can be fired, and then the next thing is like they're on social media and they're like, and all
sometimes
the bad stuff they're writing about. No, yes, you could support.
You'd be like, this person is actually
yes,
right.
Yes, you could support, but it's unfair to us as lawyers because if I'm going to court I would love to present to court that actually my client is not in fault, it's the other party in fault. Now,
that also matters.
When you do something that would probably put your character in reputation, that also has a consequence on what we want to get from court from your employer. So in any case, I would advise that in case you realize that, you know, when you have your power, you know you're an employee, this guy isn't wrong. You don't have to so much go on social media, write all that nasty stuff against them. No, you can just handle it, you know. Just go to your lawyer, visit your lawyer, and then see how you can go about it. Yes.
So where can someone report the unfair dismissal?
So unfair dismissal, the unfair dismissal, you must go to the labor office. The first place, before you go to court, you must go to the labor office. And in case after the time of termination or dismissal, within 3 or 6 months, you must try as much as possible. To be more than 6 months, you cannot bring a claim before the labor officer. So you must make sure that between 3 or 6 months, you've been able to bring your claim before the labor officer. And then after, from the labor officer, it doesn't mean that it's the final place. That is a place just for mediation. Previously, previously in the start, you had to go to the labor office. Probably even the labor officer could do arbitration. But under this act, the labor officer cannot become the arbitrator. So you can go to the industrial court or even the high court that takes that place. Or even because even also the chief magistrate's court, now there's been also amendment on the powers and the jurisdiction of the chief magistrate's court. So you can also go to there, but after you've come from the labor office. Yes.
And then after all that, is there, like, what is needed?
What is needed?
Yeah. When you're done with all the labor, okay, you've gone there, what are the things that they will request?
The first thing you need to do before you, because you see, under the law we have to claim that he who alleges must prove. So if you're alleging that I've been unfairly terminated, wrongfully dismissed, then the burden is on you to prove that actually you've been unfairly dismissed or you've been wrongfully terminated. So in this case, you must make sure that, like we said in the start, make sure you have that contract with you. You know, many people, when they get after the job, they say, oh, congratulations.
That's what I'm saying.
You know, at the end of the day. And yes.
Mind you, you find, usually the HRs give you a copy of your contract.
Yes.
But you find most of the people, once they sign and then they give the original to the HR, is it the original that we keep?
Yes.
Or anyway,
a duplicate of whatever that is.
And then you find the copy is somewhere at home, like you don't even know where it is. So when things happen, you find the lawyers asking for evidence and you don't even have the contract.
Yes.
What else can we do?
You don't have a contract, you never read it very well, the clauses. Your appraisal forms, people have appraisal forms, they actually let them go, they do not look at them, they do not actually keep them. Some of them have systems where you have those appraisal forms. So those are things that can actually be of good help. Because if the employer is saying, you've not been performing, but here you are, you're getting 90%, you're being promoted day in, day out, that's all evidence that you need to have. And in case also, you can show, maybe let's say, now we talk about sexual harassment. It's in the workplaces. Now you find that you've been having that boss who's like, oh, please, whatever it is. And then here you are, and the guy is saying, because you've refused, I'm actually going to dismiss you. So that's evidence you can actually as well say, oh, WhatsApp chats or voice notes or what. And you know, that you can bring it to say, actually, by the time these people dismissed me, actually, it is because of this and this that these guys dismissed me. It wasn't because of that. It was because of this sexual harassment that this person dismissed me. It was by the time that I actually applied for my form, maybe my leave form for my sick leave or paternity leave or maternity leave, and the time was still there. But the time that I was dismissed or terminated, the time had not come to that.
True.
Yes.
So let me just give a scenario, Simon, okay? Let's just say I do not have the copy of the contract. And I was dismissed unfairly, and you know, I really need help, like I want to report them or whatever. What are the things you can help me with if I do not have the evidence? For example, if I do not have the contract, the copy of the contract.
No, that's why I say you need a lawyer. At some point,
as
a lawyer,
I've come to you.
Okay, yes. The first thing I would do if you don't have a contract, first of all, I would look at maybe your interactions, your emails as well as possible. Or if possible, you know, there's what you can put like, you know how when you have a rat or something like that, you put something and then it comes and eats it. So you can throw some stone in the bush. Then there will be that HR who will just send you the contracts. And then you say, okay, during the mediation, maybe you can say, let's have a mediation. So if you find that there's an HR who probably doesn't, you know, he may give you that contract, then you have a look through it and then say, okay, maybe see. And then you see where to start left, right, and center. But also policies. You may look and say, please, there's an HR policy that says this and that and that. So during the time when you're having a labor officer, you can probably also get some evidence that could be, during the time when you're putting, you could put some, like I said, some small things, that guinea that will get the meat or the rat, whatever it is. So you can put something that maybe during the time when you're at the labor office will probably get you that evidence. So I could say, okay, well, during the drafting of whatever it is, my complaint before the labor officer, and then probably an HR may be able to give me that contract of service, and then, or during the time when doing litigation. So, but it's advisable. Keep that contract for yourself.
I think, I would say, let's keep our contracts. Let's not throw them.
And also act well at the workplace so that you don't, at the end of the day,
you don't have to look for a lawyer.
You don't have to look for a lawyer. But then also protect your rights and advocate for your rights. Do not be there to just, take it for granted. You have your rights as an employee, and those rights must be protected.
I think, for those who are watching us, please remember you have rights. So do not let employers step on you. But again, do not protest, as you said. Sometimes protesting might lead to,
I do not say that do not protest.
Yeah,
what I'm
but
saying is that do not, that some people who can go to the social media and then they just, at some point, all I'm saying is that it could affect you in
That's
the time of the award that you probably would get from the industrial court. So at least you can have, where they need be, you could be advised by your legal officer or an HR practitioner or any of the above.
And then also the last question, where should we get lawyers from?
Where should you get lawyers from?
Let me just say, for example, I don't know where to start from.
Well, there are very many lawyers in this country. In fact, there are quite many. There are quite very many. But I advise people that during your referrals, the people that you talk to, people can be able to advise and say, oh, this is a lawyer that I can know. But also before you get that lawyer, try to find out, follow up, and make a background check of this lawyer. How have they been acting? How have they been doing? How are they doing? So also, but you can look out. There's internet. Check out which law firm and check out law firms in Uganda. And then look out and see which law firms are dealing with employment law. But then also, look for people. Reach out to people that can say, oh, by the way, do you know about of this lawyer? When they tell you about that, then make a background check. Then also you can engage them.
I think
because for us, the law that we have that governs us as lawyers, we don't go around marketing and say, I can do this.
We are good.
Yes. So the referrals or the networks that we're in are actually the ones that actually,
I think that was helpful. Now I know where to get lawyers from. But I think...
Or you can even go and visit Uganda Law Society and ask and say, is there any lawyer that you know that is very good at employment law? And then they can be able to,
I think that makes sense. That makes sense. All right, I think that is the end of our conversation. It was actually great. And I think we might have you back again. It depends. You know what they say? If the viewers say we want Simon back, we'll definitely call you back.
The pleasure is mine.
And I hope you've all taken notes because this was really useful for those who have been not knowing their rights. Just know you have rights at work. So that is it for today. For today's episode, we had Simon back. Ladies and gentlemen, thank you for watching us. And please, if you're new here, you're welcome to the family. Don't forget to subscribe. Also follow our socials. We're on TikTok, Twitter, Instagram, and also YouTube. So please subscribe and please spread some kindness. Thank you.